Alright everyone, it's a good day for the First Amendment, and those come less frequently these days. The Supreme Court has ruled on a trademark case involving the band The Slants. Now, the idea was before there was a rule the government wouldn't issue you a trademark if the trademark contained anything that could potentially be offensive, racially disparaging, and so forth. Although they granted trademarks for things that mention like squaws and stuff like that. I hate to say it, it's basically the same concept. We all know about the Redskins case. They're constantly being told, oh, you need to get rid of the Washington Redskins. I don't know exactly what they're supposed to change it to. The Washington Firewater drinkers, or so, would that be less disparaging? Oh, it's just an alcohol reference. Oh wait, maybe that'd be a problem too, because the government wants to play moral police. But the Supreme Court told them no, the government can't discriminate against people filing for trademarks that might be seen as offensive. Because what it amounts to is the government's claiming it's exercising its free speech in granting trademarks through the government. But it's not actually a form of speech. The government doesn't have speech. So that was the problem. And it was a unanimous ruling. It wasn't a split decision, which is remarkable. All 8 justices ruled in. Now, Gorsuch wasn't involved in the case because he hadn't sort of taken his place there when the case began. So it was 8-0 in favor of the ban and in favor of free speech. Essentially, the opinion was split, however, 4-4, between those who said, no, the government can't police speech at all. The First Amendment specifically and explicitly is there to protect unpopular, disparaging, offensive speech. That's the whole point, because nobody needs to protect popular speech. And then the others were a bit more hesitant to be more broad in that manner, and simply said, well, the government itself can't really do anything about this. Has to do with trademark. They limited their opinion specifically to the realm of trademark. But this sets a wonderful precedent in the future as far as the common sense and a proper interpretation of the First Amendment would be, for example, hate speech is free speech. If you are not making a credible threat, slandering somebody, breaching copyright, or criminally harassing somebody, whatever you're saying is perfectly acceptable, is perfectly legal. Others have the right to weigh in as well. They have the right to say that you're, scummy for saying something that they find to be bigoted in some way, but you have the right to say those things, and the government can't stop you. And they can't stop you from filing off trademarks on phrases that would be considered discriminatory in nature, that would be considered offensive, because the government is not there to police what people can and cannot say, can and cannot express. And I was happy with their specific wording in the opinions that they gave. Specifically, they mentioned the fact, yeah, the First Amendment, it's specifically for unpopular speech, not for popular speech. And that's a very, very important thing. It's not so much just, well, the government can't tell you what you can and cannot trademark. It goes further than that. Even the justices that held back a little bit joined them in that part of the decision. So it's very, very good for the United States that this decision came out the way it is. They also seem to be rather happy about the fact that this band is trying to take a racial epithet and simply make it something innocuous. So you might think of a band called the Honkies or something like that in the future, and that's a good thing because that really does help. Free speech is the most important thing we have, and this permeates the online realm. Most of what's going on on the internet at any given time specifically falls under the umbrella of speech and expression. It's like the e-commerce side is almost secondary, because even when you're marketing something, you have to speak about what it is you're marketing. You have to express, why would somebody want this product? What kind of product is it? It has a name. It has a trademark potentially behind it. And if the government is enabled to restrict the commercial side, specifically limited to commercial speech, then it becomes a big problem. And they pointed out that the current reigning trademark law wouldn't even hold up to that much looser standard that's usually applied to commercial speech, let alone the First Amendment in totality as it applies to the general population. So this is about the best decision that we could have possibly gotten. This is a big bulwark in the face of those that would want internet censorship. in the face of those who want PC-only sort of trademarks. They just lost big time. Good. It's going to be good to see people be able to say things in trademark terms that are unpopular. Something like the Redskins. Something like, Squaw Soap, or whatever you would imagine under the sun. Or the Slants. It's a band name that might offend. It would specifically offend people who are more like politically correct, more racially sensitive or something. Even though their express goal is sort of removing the epithet style of the actual term, the Slants. They would be the ones offended by it. Like, I don't care. I think it's a band name. You know, you can call it anything else. You can have a band called Satan 666, I Killed Jesus, but you can't have a band called the Slants because the government says it's unacceptable. Well, they just lost the ability to police trademark in that manner. Good. Now, the government needs a lot less rights. People need a lot more rights. That's about all. Peace out.